Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
Good afternoon and welcome to the 14th Court of Appeals and welcome to our oral argument this afternoon by Zoom. I'm Justice Frances Borleo and I'm joined today by Justice Jerry Zimmer and Justice Charles Spain. We have one case on the docket. The cause number is 14-19-00915, Energy Transfer versus JSW Steel. Would counsel please make their appearances for the record?
Chris Dove for Appellant ETC Interstate Procurement Company, LLC.
Thank you.
Mike Seeley for Appellee JSW Steel USA Inc.
Thank you. And you have reserved 4 minutes for rebuttal, is that correct?
That's correct, thank you.
Okay. So I think we have a slight pause while we take one of you to the waiting room. And Mr. Dove, we are ready for you whenever you're ready.
Thank you, Justice Borleo. May it please the court. My name is Chris Dove. I represent the appellant in this case. As you will be familiar from the briefing, this is basically a question about, in a commercial contract, whose terms and conditions apply. That immediately affects the question before the court, which is whether it should have been sent to arbitration. But as we have briefed, it also casts a shadow on all the merits of the case and what have you, which are not immediately before the court, but play into the larger story. And as I was preparing for the argument today, I was going back through the briefing and the cases and everything, and it occurred to me that despite my agreements with my colleague, Mr. Seeley, and my disagreements with him, there's one purely legal point on which we agree. And I believe that clear, settled legal principles compel this court to reverse and send this to the trial court for a jury trial. Under the UCC, under common law, under first-year contract cases, an offer is only an offer if it states the material terms such that the other side can simply say, I agree, and form a contract. You can phrase that in whatever terminology you want, whatever case law you want. Both sides have cited multiple cases for this straightforward proposition. We believe that rule shines through as a guide for this court because when you look at the case, there were a number of communications. What this court will see is a purchase order that was sent on February 15th that has all of the usual symptoms, characteristics of being an offer. It states all of the terms, states all of the delivery requirements, and expressly states that my client ETC's terms and conditions expressly apply. It does not state that JSW's terms and conditions apply. They are not mentioned. The next day, JSW sends what it calls an order acknowledgement. And in that, it states all the same terms and also expressly states in its acknowledgement that ETC's terms and conditions apply. That is, we think, the clear, simple fact that makes everything else pale in comparison. If you then even go back one day, as you look at the history that's in the record, a draft was sent by ETC, very carefully labeled a draft, saying, all right, this is what we're thinking of sending you as our purchase order. If you have any comments, let us know. The only thing that they changed in result of that is the delivery date. That was adjusted because the draft was the first time the delivery date had ever been stated. This critical factor, this point where all the way back to the very first price quote, it had said, now we're going to have to discuss delivery dates. That's going to be something we'll resolve mutually in the future. That's the first time that it had ever been resolved. And we said, do you have any comments? They did not change the fact that it incorporated our terms and conditions. And then we sent it in. Furthermore, if you look at the two competing sets of terms and conditions, it's fascinating to me. ETC's terms and conditions, because ETC is a buyer It builds pipelines. It's accustomed to buying pipe. Everything is phrased in the form of, this is our order, and this is how you may accept it. You may not accept it by changing the terms expressly stated in this document whatsoever, unless we expressly agree to change it. That never happened. Meanwhile, JSW's terms and conditions, because they are a seller of pipe, are expressed in the form of acknowledgement. If we send you an acknowledgement, you don't get to change the terms after we acknowledge it. Well, that's fine. Their acknowledgement that they sent us.
Excuse me, isn't it true that their terms and conditions also say that acceptance of any purchase order and or sale or any goods are expressly made conditioned on your assent to these terms and conditions? So just as you say that you require them to assent to your terms and conditions, so they had the very same assent to their terms and conditions. So how do we resolve that?
Excellent question, Justice Zimmer. And I'm certainly not denying that we are in court today because there are conflicting terms and conditions. What I had meant to emphasize is that one is from the standpoint of an offer and the other is from the standpoint of an acceptance. But you're right, they're inconsistent. That's why we're here. And that's why I think that the central question that resolves this is the question of, when was there an offer? Because our position is there cannot have been an offer before that order that was placed on the 15th. Before that time, there was nothing that met the definition of an offer that could be accepted under the UCC, under common law, under first-year contract hypotheticals, however.
Could you?
First price quote. I'm sorry, I don't mean to interrupt.
I think you're about to answer the question I was just about to ask, actually. So please.
Their
continue.
first price quote cannot have been an offer for several reasons. The one that they sent on February 1st. First of all, it expired. It expressly states this expires on February 7th. Under the UCC common law first-year contracts, that makes it dead. Furthermore, it left terms open for further resolution. It did not do that thing you can do under the UCC where you say, this is something we're going to leave unsaid and let law fill in a gap. It said, we're going to talk about the production schedule and the delivery date and fill that in later. So this is clearly something they knew had to be resolved. And it expressly contemplates that there's going to be an order in the future. Well, never mind, says JSW. After it expired, we sent this other answer. You had asked for further information. The context of all of this is, of course, a request for a quote. We'd said, what would your prices be if we wanted to place an order? They sent this. We added some more information. On that one, they had changed all of the prices, quantity specification, and then, so they sent another one on the 9th, in which, once again, we're changing material terms and still have not resolved the important question of the production schedule or the delivery date. Then, on the 12th, after all of this has happened, they send another email saying, hey, we haven't heard from you, and heads up, the delivery schedule is a problem because we just accepted another order. This is going to be something that's going to be pushed out further. We're going to have to work this out. All right, there were further negotiations went on. What this culminated in, the first time it ever resulted in something that under this single rule that guides everything, that rule that all the material terms were clear, such that you could say, I accept, was when we placed our purchase order. It would have been one day earlier, except that we had said on it very clearly, this is a draft. This is just a draft. Send us your comments. That was a clear statement. So then when we sent it in, this is the first time. None of the material terms have changed. We now have a delivery date. We now have a production schedule. All of this information is full. And so when they accept it, that is the acceptance. And so, Justice Zimmer, the answer to your question is, having attached their terms and conditions to a series of discussions, after we had attached our terms and conditions to our invitation for them to give us a price, that all falls away because none of it was an offer. The contract consists of the offer and the acceptance, which accepts all the same material terms.
Wouldn't you agree that the UCC applies to this case?
I do agree that the UCC applies to this case. What I do not agree with respect to my colleague, Mr. Seeley, is that it somehow creates a new rule that allows them to evade what seems like common sense in this case. The UCC simply takes ordinary rules and puts them in a certain context. One area where the UCC would be different, admittedly, is the famous Battle of the Forms provision, in which it can change the way in which you accept an offer. Both parties have terms and conditions that disavow the Battle of the Forms. So that doesn't apply. However, generally speaking, if you're asking, what about Section 2204, which talks about the manner in which an offer is expressed? Yes, that is correct. I don't believe it's fundamentally different, but yes, it does apply. 2206, which explains the manner in which merchants can express their acceptance. I don't think it matters in this case because there was a very clear offer and a very clear order acknowledgement. I think that takes care of that. 2207 does not apply because both parties took pains to disclaim it in the way expressly allowed by the UCC.
So we have a Fifth Circuit case that holds that ongoing negotiations could extend the time frame outside. Basically, the negotiations are extending the offer period. Do you have any Texas case law addressing how negotiations would affect the offer and acceptance period?
Justice Borleo, I assume you're talking about the Axelson case?
Yes, sir.
I think that Axelson is a perfectly fine description of the law and the way that it works. And as you look at the facts of that case, it draws the line exactly where it needs to be drawn. It's just that we're on the correct side of it. If you have an offer that expressly expires, and then you in writing, as happened in Axelson, say, I extend this date to a specific future date, and then it's accepted before that date, that's fine. Everything is spelled out exactly as it would be. This is different for two key reasons. And if I may finish, this will take me a tad bit over my time.
Please, yes.
First, that date was never expressly extended as it was in Axelson. The deadline had ended. The next day, there was some further talking, but what had been this answer, this price quote, whatever you want to call it, had expired. Secondly, whatever they sent on the 8th and 9th still wasn't an offer by any legal standard. It had remaining terms unresolved. The parties went back and changed material terms. They still did not have a production schedule. They did not have a delivery date, as their further negotiations proved. So even if the rule were other than Axelson had stated, they still wouldn't have an offer that is binding.
Thank you.
Thank you, Your Honor.
May it please the court. The first question that the court is going to have to address, and maybe the most important one, is what is the proper standard of review to evaluate the trial court's decision? In fact, in its reply brief, ETC poses a question and says, is the existence of an agreement to arbitrate a factual determination or a legal determination? And this very court answered that exact same question in Morgan v. Bronze Queen Management Company in 2014. There, the court was analyzing in the context of an arbitration agreement, offers and acceptance, and the court found whether the parties reached an agreement is a question of fact. And questions of fact are given an abuse of discretion standard, whereas questions of law are given a de novo review. In fact, even the cases that ETC cites, for example, Henry versus...
Isn't that really the crux of this entire case? I realize that your trial judge probably had difficulty understanding the distinction between formation of agreement and arbitrability, which is what is arbitrable under the contract. So that's a really good analysis that is this a legal question or a factual question? And I suppose the legal question then is whether or not the communications back and forth established arbitration in this case, whether or not the parties agreed to arbitrate. Isn't that true?
I I agree that whether the parties agreed to arbitrate is the fundamental question that has to be answered. But according to this court's opinion in Morgan, whether the parties reached that agreement is a question of fact that the trial court judge has to be given deference on.
But in this case, the unique thing about this case is that we have a very clear paper trail where that supposed assent to arbitrate is very clear between the if you would, the forms that are going back and forth. In other words, there's not a factual dispute here between what the two parties are arguing, is there?
I think there is a factual dispute over the interpretation of that particular, what means what, but the trial court is given deference to make that decision under both Morgan and Henry v. Cash Biz, relied on by ETC, where there the court said the same thing, that factual questions, such as the formation of a contract, are given that abuse of discretion review. Now, if this was a question where they came in and they said, well, we don't know whether or not the claims fall within the terms of the arbitration agreement, or they were challenging the conscionability, or there was a waiver question, those are all legal questions that would be given de novo review. But because the only dispute, both then and now, is whether or not, well, there's no question an agreement was formed, but when and how, that is a factual dispute that the trial court has resolved. And just as if a jury had resolved it, regardless of, the fact that the Court of Appeals can view the evidence and make a decision, the standard that has to be applied is an abuse of discretion. And in that context, you then look at the contract formation questions. And although ETC did not take this position in their original brief, I think we can all agree now that this is a UCC case. And there are a number of UCC cases that deal with these goods and this type of question. The first one that we cite for the court is J.D. Fields versus U.S. Steel, and consequently, that was another steel pipe case. And there, the Fifth Circuit said that contract formation is a question of fact under Texas law, and when the parties enter into a contract for the sale of goods, the UCC applies. And when the UCC does apply, it displaces all common law rules of law regarding breach of contract and substitutes instead those rules of law and procedures set forth in the UCC. Now, that's important because when you take a look at ETC's brief, you will see that they rely on the mirror image rule. They say that acceptance is only valid if it complies strictly with the offer. They say no contract can be formed until each essential terms are made clear and definite, and that is all contrary to the UCC. In fact, Section 2.204 says a contract may be made in any manner sufficient to show agreement and may be found even though the moment of its making is undetermined. In fact, 2.206 says an offer to make a contract shall be construed as inviting acceptance in any manner and by any medium reasonable to circumstances. And so with that as a background, I think we have to talk about the entire timeline of this event and not just the dates of the February 14th, 15th, and 16th. What we know from the record is that on January 30th, 2018, ETC sent JSW an email and requested a quote. And to that request, they attached their terms and conditions. In response, on February 1st, 2018, JSW provided a very detailed quote that laid out almost the entirety of the contract. In fact, under the UCC, if on that day, ETC said, I'll take it, a contract would have been formed. But importantly, attached to that email was JSW's terms and conditions. And as the court pointed out, they specifically say all sales by us are made subject to these terms and conditions. We expressly reject any different or additional terms or conditions contained in any document submitted by you. Our provision of credit, acceptance of any purchase order, and or sale of any goods are expressly made conditional on your assent to these terms and conditions. That document is transmitted on February 1st. It's transmitted again on February 8th. The parties then continued to negotiate, and it was minor details. They wanted to change the coding. Instead of 40-foot joints, they wanted 80-foot joints. But there was a continued negotiation, And in fact, the continued negotiation in this case, it's not much different than the continued negotiation in Axelson. And I disagree with opposing counsel's characterization of Axelson, because there, while there were 2 extensions of the original date on the quote, the purchase order was not issued until 6 months after the expiration of those extensions. In fact, when you read the case, you will see in July of '84, Axelson sends it quote and says it's valid for 60 days. Revision 1 extended it to November 12th. Revision 2 extended it to December 31st, '84. And the court found the new year arrived and the parties had not yet concluded the contract, but they were getting closer. That is the same situation that JSW and ETC were in, although this took place over a period of just over 2 weeks. On March 7th of 1985, there was an intention for commencement of a purchase order, and the purchase order is actually issued on June 4th, 1985, 6 months after the expiration of the last extension. The court found that the quotation from Axelson can be construed as an offer. The court then went on to say the telex quotation of July 12, 1984 contained all material terms, but lapsed on December 31st. But ongoing negotiations between the parties show the terms of the quotation, after being modified by negotiation, were still subject to McAvoy's acceptance. That's exactly what happened here. They asked for 2 grades of pipe on January 31st. There was a quote to provide it. The parties negotiated over the details, and ultimately they accepted JSW's offer on February 15th by issuing a purchase order.
Well, their purchase order didn't entirely just accept it outright. They had their own terms and conditions. Was there anything in those terms and conditions that expressly rejected the terms that JRW had?
I do believe that there is a standard form provision that says that their terms and conditions apply. Now, those terms and conditions.
Did those terms and conditions expressly reject your previous terms and conditions?
I don't think that there is a specific language that says we reject terms and conditions. I think that opposing counsel is right that their terms and conditions say it will govern the issuance of their purchase orders. And so there is a question there, but the reality is that when that email was transferred on February 15th and the email said all material documents are attached, the terms and conditions were not attached in that email. In fact, they're not transmitted until March 8th. Another interesting point is that
they were referenced, and they actually went back to the original RFQ where they were attached, which is interesting because the RFQ was not, by their own briefing, was not an offer. So,
exactly.
So I suppose what they're asking is that we infer that since there's a reference, that we would infer that you were aware of those terms and conditions as well. But go back, the question I have is, was there anything in their terms and conditions that expressly rejected? You rejected the RFQ. You rejected that expressly. You said, we expressly reject any different or additional terms. Was there anything similar to that?
I don't recall as I sit here today. I will have somebody look at that and I can have an answer in the next 4 minutes, but I don't recall that express rejection language being contained within their terms and conditions.
Okay.
What I do know is that it was referenced on their purchase order was also the quote that we had originally given, which was the email string that contained JSW's terms and conditions on 2 separate occasions. So they can't just say, well, our terms and conditions were referenced, so they're in, even if they weren't attached. But we also referenced your quote, but even though it had terms and conditions twice, we're going to ignore that. They want to ignore the basic mechanics of emails. And emails is a string, it's a conversation. We provided it, they respond, we provided terms and conditions again. And if in fact—
May I ask you to spend a few minutes addressing the post-judgment interest question? I don't want to get too far into this and you not be able to address that issue as well.
No, I will address that. The only thing I would like to reference the court to is Wade and Sons, which was a similar condition where the court had this exact issue and said, we don't have to get into the battle of the forms or the offer acceptance, because the purchase order referenced the original quote, which had terms and conditions, those are part of the party's agreement. And so, and it's interesting, even if the court were to find, or if the trial court had found that both parties' terms and conditions apply, JSW's has terms and conditions that require arbitration, and ETC's is silent. So even if you had one agreement with both terms and conditions, arbitration was still the way to go. But the post-judgment interest question is interesting because the arbitrator issued 2 awards. And the first time she was very clear, it's 18% pre-judgment interest in accordance with the contract, and that will continue on until the award is paid. Opposing counsel asked to have that changed to the judgment without any explanation, and that was changed. And it makes sense in some contexts. In fact, you'll see the email that he says is that the arbitrator can't award interest post-judgment. That's to be done by the court. And so you get into analysis of whether or not the trial court can award interest, and if so, at what rate. Now, this agreement provides for the application of the Federal Arbitration Act. And the Federal Arbitration Act preempts inconsistent state law where a contract chooses the FFA. And under the FAA, a judgment so entered shall have the same force and effect in all respects and be subject to all the provisions of law related to a judgment and an action, and it may be enforced as it had been rendered in an action in the court which it is entered. That is substantially the same law in Texas. We had an arbitration award, we reduced it to a judgment. And Texas law has been clear that all judgments are entitled to post-judgment or post-judgment interest. In fact, it's been found to be so fundamental.
This really isn't a judgment, is it? It's a confirmation of the arbitral award.
I would argue that now it is a judgment. It's subject to appeal, just like in a judgment. There is a supersedious bond that has to be taken place, has to be posted just like a judgment. It is enforced just like a judgment. If they don't pay, I can issue post-judgment discovery on it. I can have a turnover order. Once the arbitrator's award is confirmed by the trial court, it is a judgment for all practical purposes. And to treat it differently just because an arbitrator entered or made the decision as opposed to a trial court, there's no fundamental reasoning behind such an analysis. I mean,
So what about, but in the first Court of Appeals under Thompson, they absolutely disagreed. I believe that was Justice Bland that said that actually says that by expressly invoking the FAA and the arbitral process, we hold that party waived its objections to the trial court's application and its conforming of the arbitral award. So didn't the first court, this may be a case of first impression for the 14th court, but the first court has already decided that issue, haven't they?
I think that the first court addressed the issue, but not directly in this manner. And the reality is there was trying to be an addition of interest where none was awarded. That's not the situation we have. We do have post-judgment interest awarded. It's just not at the rate that was in the contract, which the Texas Finance Code would require. So if the rule is, and I see I'm out of time, if I could just finish this thought.
Yes, would you please? I may have one more question for you.
If the first Court of Appeals rule is that post-judgment interest can't be touched after the judgment, then that is what it is. I don't think that that's correct. But the reality is that it is a judgment, just like any judgment, is a money judgment from a court of law. And under the Finance Code, it should be entitled to the same post-judgment interest as would be pre-judgment interest.
All right. Well, also in that same case, they addressed the Texas Finance Code, and specifically Justice Bland found that the Texas Finance Code applies to judgment rendered by courts and do not apply to awards rendered by arbitrators. So that might be something you might want to look at.
I understand, Your Honor.
So anyway, that's the first Court of Appeals, and this is the 14th. So this is a matter of first impression for us, I believe.
I believe that's correct, Your Honor. And I see my time is up. I'm happy to answer any additional questions, or I'll sit and let opposing counsel finish.
Thank you.
Thank you.
May it please the court. The timer hasn't restarted. There we are. If I may begin by going directly to a question that Justice Zimmerer asked, here is the language from ETC's terms and conditions that expressly rejects contrary terms. It's in paragraph 1 on page 45 of the clerk's record. Any acceptance of this purchase order is limited to acceptance of the express terms contained on the face and back hereof. And then it goes on to further say, if additional terms are proposed, we would have to agree to them. And if not so accepted, the terms of this purchase order shall prevail. That is the express statement. We will not accept anything but what we have put in ink ourselves. I would like to talk about another issue that came up during your colloquy with Mr. Seeley. 3 different issues I noted all came back to the same underlying concept that I would like to clarify and emphasize to the court, if I may. And it has to do with the meaning of ETC expressly stating our terms and conditions apply, which is something that JSW never did. This is not a case in which both sides merely attached terms and conditions as an attachment to an email. ETC began with its request for quotation by saying an applicable attachment to this request is our terms and conditions. We said this is applicable. So it's not as if somebody might overlook the attachment. We said this is part of the deal. It's expressly incorporated. We did the same thing on the 14th in our draft purchase order, the 15th on our purchase order, and JSW did the same thing on the 16th in its order acknowledgement, each time expressly stating that ETC's terms and conditions are incorporated. Under Texas law, and we've cited the cases in our briefing, Owen versus Hendricks, my mind is blanking, it's the Bob something Chevrolet case, I apologize.
May I ask you a question? I know our time is
Yes.
short, but so I recognize your first argument that you just mentioned, which is that the ETC claims if there's a conflict between our forms, ours controls. But if you apply the severability rule to the arbitration provision, is there anything in the ETC document that actually expressly rejects arbitration?
Nothing in ETC's document expressly refuses to arbitrate. It says we will not accept any contrary terms. And our position is that that includes arbitration.
Is that a conflicting term?
I think it absolutely is. Because there's no way one would read the terms and conditions and assume that we have agreed to throw away our right to a trial. And in fact, if I may, I believe, I don't want to steer you wrong. I can't find it as I'm standing here with my time ticking away. The question is whether there's a reference to a venue or something like that that specifically acknowledges a court. But I believe it is in conflict. And generally speaking, when we say our terms, and it has to be written on this page by us or we're not accepting it. Plainly, we didn't write, we agree to arbitrate on that document. And the last thing that I would say, if I may, just to wrap up, regarding the question of post-judgment interest, Mr. Seeley says there's no logical reason why you would draw a distinction between rules that apply to supersedious or enforcement of a judgment and what goes into the creation of the judgment. And I think that's exactly backwards. The rule that we're talking about here has to do with whether a trial court has the power to adjudicate the merits of the case. And the Arbitration Act say you may not. That is, for the arbitrator, you've decided that. All you were doing, as you noted, Justice Zimmerer, in the first court's cases, in the Fort Worth court's cases, in the San Antonio court's cases, in the Austin court's cases, as they all say, what you are doing is a ministerial act. You are giving effect to an adjudication of the merits done by an arbitrator. Now, at that point, once we have given the arbitrator her full due and respect, now what do you do with it? Yes, you may apply the rules regarding how you supersede it, how you enforce it, and so on. But you don't get to take rules that apply when a court adjudicates the merits and use them to delete language put into the arbitral award by the arbitrator. If the court has any further questions, I'm glad to answer them. Otherwise, thank you for giving us your time in this remarkable way in this remarkable year.
That's right.
Thank you. Thank you both for your briefing and your arguments. Cause number 14-19-00915 is submitted and court is adjourned. Thank you.
Thank you, Your Honor.